Okay, Ms. Jones, any other motion you wish to proceed on?
The last motion that I drafted, Judge, was the motion to introduce the alternative perpetrator evidence.
Okay.
And Judge, I've attached two pieces of discovery that were provided in the Commonwealth's production to us. One of them includes an 8-page summary which lists 21 reasons why the alleged the person who drafted it believed that Mr. Henson was the perpetrator, one of those being that he had admitted to the killings on multiple occasions. The second is handwritten notes, I believe to be Billy, Lieutenant Gloyd's, I don't know what his current title is, but to be of Officer Gloyd's notes from interviewing a Teresa Abbott. Teresa Abbott indicates that on multiple occasions that Mr. Henson had admitted to her that he was involved. I believe it gives more extensive details into why she believed he was involved. He did have previously, I think as late as July 31st of 1994, had been to the New Life Fitness and Massage. There's credit card receipts to that effect. Gray is the presiding case that has just recently been decided and returned because the appellant wasn't allowed to introduce the alternative perpetrator evidence. I think that it ultimately, our case, we will be handicapped detrimentally, prejudicially, if we are not allowed to introduce this evidence into the record.
Tell the court how you, obviously, in the mind of the court, a person accused of a crime would have a constitutional right to prove it wasn't. They have no burden to prove that it wasn't them, but they have a right to prove it's somebody else. How do you intend to go about offering that proof?
And Judge, that's been a subject of conversation. Maybe Mr. Buffkin might be, I think he's planning on filing a motion specifically to that effect to allow that evidence through Crane and, what was the other case? Gray and Crane, that our due process rights will be substantially violated if we are not allowed to introduce that evidence.
But do you have any person that would testify from the witness stand that supports these written statements that Teresa, yeah, you mentioned
Abbott, Judge, she passed away in March of this year, and I might be able to, Miss Mize might be able to better answer that question because I believe her investigator has actually spoken to Miss Abbott prior to her passing.
All right.
She did, Your Honor. Miss Waltz, who is the investigator, and Mr. Duncan did contact Miss Abbott last year before she passed away, spoke with her, also spoke with her daughter at that time, and even received text message communications. So she would be able to testify firsthand about some of these statements before Miss Abbott died.
I see. Okay. All right. Mr. Miller? And I didn't want to cut you off there if you wanted to say any more before we hear from Mr. Miller. That's fine.
Well, I guess let me go backwards. Let me speak to that. I have not received any kind of reciprocal discovery on that conversation. I'm not aware of anything that Ms. Abbott said to anyone, quite honestly, based on the veracity. Let me go back to the motion. The Gray case purports to soften the Beatty case, which held that the defendant had to establish motive and opportunity before an all-perp theory could proceed. Gray does not overrule Beatty. The motion and opportunity are still valid. Gray just says that's not the only way to do it now. The admission is still dictated by Rule 403. What the defendant seeks to admit, and I think the court has looked at that, is a typed sheet with no established author. It doesn't say Miss Abbott anywhere on it. It doesn't say Teresa Abbott. It doesn't say who authored it at all. It's mere speculation as to who authored that document. There are credit card receipts that they can't authenticate and doesn't correspond to the date of the murders. I think July is the credit card receipt. The murders happened in September, late September. There are handwritten investigative notes they claim are Major Gloyd's, but I'm not even sure we can determine those are Major Gloyd's notes. It's something that maybe shouldn't have been provided in discovery, but to be honest with you, this case was such a quagmire, I felt it better just to give them everything. The statements constitute inadmissible hearsay, even if Ms. Abbott were alive, and so I'm not sure exactly how they're planning on getting that in other than through the investigator they just mentioned. The evidence is not reliable by any stretch. Gray establishes the alt-perp standard. Motive and opportunity are still relevant and important considerations because it's an assured way to determine admissibility of evidence. In the Gray case, there was evidence of a motive. There is no evidence that Mr. Henson had any motive or opportunity in this case. The evidence they seek to introduce lacks probative value because of its inherent unreliability and serves only to confuse and mislead the jury. So I would object to the alt-perp theory at this point. I would suggest perhaps the court hold off on ruling that until Mr. Bufkin files his, I guess, supplemental motion to this and let the Commonwealth file a response on both.
Okay. Yeah, I'll reserve ruling on it. Mr. Buff can file whatever additional motion that's kind of related, and the Commonwealth can file a response to both.
If we could get a deadline for that, that would be
When
helpful.
when do you anticipate filing what you plan on filing, Mr. Buff?
I can have both those motions ready by Friday.
Okay. Would you then email them to?
Yes.
Okay. Is that satisfactory, Mr. Miller?
Yes, sir.
Okay. Now, I saw something in what was filed that, and I didn't study it closely, I didn't have time, that could arguably be a motive. So I'll look at all of that when I get it. All right.
I
Thank you further.
believe those are all of the motions that I drafted.
Thank you very much. Mr. Buffkin?
Yes, Your Honor, thank you. The first motion which I'd like to discuss is the motion to redact statements which include hearsay and/or other inadmissible content. And I gave an example for one example, there are numerous, that in Mr. Carter's statement, transcript of October 5th, 1994, there are references to instances of alleged domestic violence that have nothing to do with the instant case. There are 403 evidence that has been disallowed and should be redacted. It doesn't elicit anything to have to do with this case whatsoever. There's additional hearsay, for example, and there's a number of places where it is, and we need to go through it. References, for example, to it's part of an investigative technique or whatever, but there's a snarky response of something like, so 8 other people are not telling the truth and only you're telling the truth, and it's basically the law enforcement officer vouching for 8 other witnesses that their statements must be truthful, and therefore Mr. Carter's statements must be untruthful. And I think that vouching is not permitted. The Ordway case, I think in particular, talks about that police officers can't give opinions as to whether or not witnesses are telling the truth or not telling the truth. I think it's clear, I think there are more than one rule that prohibits that. In addition, we need to make sure that there are any brutal statements that may exist. None come to mind right now, but I think brutal is such clear, it's basically black letter law at this point. But Bruton and his progeny say that when you can't cross-examine a witness, their statement doesn't come in. And the only solutions to that Kentucky courts recognize are either redacting the statements or severing the defendants. So if there are any brutal statements, I think they need to be redacted. And I think, in addition, any other kind of hearsay that is referenced to throughout, in particular, the statements, statements of the defendants, including Mr. Carter's statements, there are hearsay statements that need to come out. In addition, there's on the March 17th statement, I believe it is the March 17th statement, there's a reference to disallowed 404B material that needs to be redacted from the statement. I think all of those are supported by law, and I think they're clearly things that have to be redacted. I don't think the courts are unfamiliar with the process of redacting. I think it's a common practice to separate basically the wheat from the chaff when you get into a situation like that where there are a number of instances of illegal material coming in through a statement. We try and keep that out.
All right. Mr. Miller?
Judge, anything the court's already ruled on 404B or otherwise obviously kept out by rules or case law, I don't have an issue with. My biggest problem I've got is we've got an audio statement that I have no possible way to edit at this point. We're either going to have to agree on where to mute it,
Okay.
or some other thing the court or counsel can come up with, and quite honestly, I just, there's no way for me to edit
Yes.
that statement at this point. The 8 telling the truth and Mr. Carter lying statement that Mr. Buffkin referred to, there were several other witnesses, obviously at the massage parlor, that were given, detectives were given facts of things like Mr. Carter making a phone call, the time he got there. The detectives, I guess, in the interview were not calling Mr. Carter a liar. They were simply saying, we've got 8 witnesses over here saying this, you're saying this. It's a black or white question. Somebody's lying, and they were trying to point out, we've got 8 people doing this, you're doing this, what's the deal? And so I don't think that is necessarily, needs to be edited out. I think that's a very important part of the conversation. I'm not aware of any brutal issues in any of the statements. I don't think they implicated each other. At that point, I certainly would agree that that's probably not coming in if there are any of those statements, but I can't think of any at this moment.
Now, as far as these written transcripts or whatever there is of these statements, those probably were not admissible anyway as far as
They were probably not. I think
Yeah.
they'll probably use the fresh recollection.
Right. Okay.
But other than that, I'm not going to introduce a handwritten transcript
Okay.
of anything.
All right. Your motion is granted, but there'll be some wiggle room that we'll have to agree on. Hearsay is not admissible. I would hope that, we're right here at the edge of the trial. If the Commonwealth would have the ability to know by counter number when some issue's about ready to be played, and we can have a bench conference or hopefully reach an agreement that we skip a segment of the audio.
Yes, sir.
Okay.
I don't know what time you're planning on starting on Tuesday, but maybe that's something we could do before, because we're not going to put the jury
Great.
pool.
I was wondering if it would, if it would make any sense, and we'll talk, that we not have the jury actually report until Wednesday, and we spend Tuesday, dealing with things like this, what I would like to avoid, but if everybody's witnesses are showing up and we need to start Tuesday, we will. I just hate for people to sit around half a day wondering, I'm here to be on the jury, wonder why nothing's happening. I would rather we be, ready to go at 9 o'clock and start with jury selection maybe the following day, but I'm not gonna rule that we gotta do that or the other. I welcome thoughts on the subject.
We've got witness flights that may interfere with.
Okay, I was afraid
I
of I was afraid of
appreciate the
that.
idea, and I think it's probably a good one, but at this point, I'm not sure.
Just no way around it. We'll just take as little time as possible and do the best we can. Maybe on that Tuesday, the courthouse, I guess, opens at 8. Maybe we all get here by 8 and get started doing some of these administrative things, because there's going to be jury qualification being done by Judge Self and Judge Atkins. So best case scenario, we wouldn't have a jury for a couple of hours or so, probably, right? Okay.
Yes, sir.
Go ahead, I didn't mean to interrupt you.
That's okay, I think I was done.
Okay, thank you.
I don't know if we planning on, or do we think we were gonna get into proof on Tuesday? Because we might be able just to stay late on Tuesday whatever we can't get done in the morning.
Since we got some people flying in and probably hoping to fly out,
I'm hoping to get into proof on Tuesday. I'm not very optimistic.
okay.
I guess depending on how the jury goes, but it won't be a lot of witnesses, maybe one on Tuesday.
Okay. Well, I suspect that we'll try to talk early and talk late. So we finish with the testimony, and there are some of these issues like this that we could go over and hopefully reach an agreement on. We would do after the jury has left for the day.
Yes.
I'm not anticipating driving home every day from this trial. Okay. That's good.
Thank you, Your Honor. The next motion I would like to address is the motion to produce any Brady, Giglio, and Kyle's information regarding Charles Daniel. But the defense included in this motion, the defense seeks, and I'm quoting from the first paragraph, last sentence, the defense seeks relief generally under Brady and its progeny, and specifically to Mr. Daniel. So what I'm saying basically is that I believe, and my understanding is that the Commonwealth doesn't object to it. Please correct me if I'm wrong, but if there is any kind of promises that have been made to people, if there is any kind of exculpatory evidence out there, if there is anything about a witness that would impeach them, I believe we are entitled to that kind of material, and I want to officially make a motion to do that, make sure that this motion is heard. As to Mr. Daniel, that portion of that statement is, that portion of this motion is not necessary if, in fact, Mr. Daniel is not called as a witness.
Okay. And I believe that's the indication we've received from Mr. Miller.
Yes, sir. I have not, quite honestly, thought about any other witnesses other than Mr. Daniel, since that was what's specifically
Okay.
in here. I will certainly look into that and get them any information that I can. I don't.
And you're obviously, I mean, I've observed you given exculpatory evidence and understand that burden and have attempted to comply with it.
Yes, sir.
And will continue to do so.
Yes, sir.
Okay, thank you. All right, next motion.
Next one. Motion to preclude the introduction of Defendant Carter's statements, no recordings turned over. Let me characterize these three statements that we have. We have, excuse me. The first statement is clearly not a word-for-word written transcript, although it occasionally contains a word or two that are in quotation marks. And there's no recording original to this statement that's been turned over anyway, that can be used to determine the veracity of that statement. And it's a statement that's ostensibly given to Billy Gloyd, but then another individual named Shoemaker, who is with the military police, is the one who actually says that he's giving his statement to clarify some other statements that were made, but there's no actual recording. There's nothing that actually verifies that. It's an unverified statement. There is a portion in the statement where an individual could have sworn to the statement but didn't swear to the statement. And I think it's And the fact is, it's just an occasional word here or there that is in quotation marks. So there's no way to check the veracity of that. There's no way to cross-examine that statement in any way, shape, or form, and I think it should be excluded without a doubt, because I think that it's going to violate Mr. Carter's rights to cross-examine, as well as his rights to due process, when we don't have any recording to verify the statement. A second statement was made on October 5th, 1994. This may be the one that Mr. Miller is referring to, that there is a recording of. I wrote in my motion that it's clearly a written transcript of a recorded statement, but no recording original has been turned over. I think that that statement needs to be further, the transcript is not verified. There's no original recording that I've seen yet, but I understand I will be seeing that, so that part of the motion is a little bit difficult, problematic for me at the moment. There's a purported third statement that exists as a handwritten transcript. The transcript is undated. There's no indication when the statement was transcribed. The transcript is not signed. There's no indication who wrote the transcript. The transcript was accompanied in discovery by a rights waiver form that's dated 3/17. However, there's a portion of the transcript that indicates the statement was made on an earlier date, or a portion of it, on February 3rd, 1995. But thus the waiver doesn't even apply, since it's referencing a statement that predated the so-called waiver. There's no original recording that exists with which to determine the accuracy and veracity of that transcript. I think this one, just like the first one, I think you've got due process problems all over the place with this, and confrontation problems all over the place with this, if there's no recording or any way to verify the statement. I mean, it's not even signed. So, I mean, we don't even know who the person is who made the handwritten transcript, and there's no way to verify it or check it and compare it to anything else. And I think that statement definitely needs to be excluded.
Okay. Mr. Miller?
Thank you, Your Honor. Judge, the first statement that was references Mr. Shoemaker, Officer Shoemaker with military police. Mr. Shoemaker witnessed the interview between Mr. Carter and I believe Major Gloyd, or then, see that, Captain Gloyd? Captain Gloyd. So if that statement, I'm not going to try to introduce that document to the jury. If anything, that would be used to refresh Major Gloyd's testimony. Same thing for number 3. I'm going to skip number 2, but number 3, again, that was an interview between, I assume, Mr. Carter and Lieutenant Moore, who will be testifying. And again, I'm not going to seek to introduce any kind of document for that statement, but maybe used to refresh his recollection. Number 2, Judge, as Mr. Buchan wrote in here, at the time he wrote that, he didn't think there was an actual recording. Again, I've advised the court there is. I think Ms. Ritchie has a copy of that, and I anticipate other counsel will find it waiting for them when they return.
Okay.
That recording is an accurate, or the transcript that everyone has is an accurate. I've listened to the entire statement along with the transcript. It is accurate and audible. I don't think there will be any issues with that.
Okay.
That being said, that statement was recorded by, or dictated by a sheriff's employee. I think that statement would probably, even if I didn't have the recording, be admissible. But again, the recording is there.
Okay. All right. Thank you. All right. Further motions?
I do think that statement is subject to the other motion for redaction purposes.
Sure. I mean, any recording that we intend to play, we got to make sure that we're not, something doesn't get blurted out that's inadmissible.
And I think it would be helpful if we do have a transcript. I'll
That will
mark
help.
markers on the transcript, and maybe we can go from there.
That would be very helpful.
My next motion
Yes, please.
is defendant's motion to preclude non-expert Commonwealth witnesses from offering speculative, conclusory, and opinion testimony and theories.
I believe Mr. Miller indicated he has no objection to that motion.
That's correct,
Okay,
Judge.
then I would just ask the court to grant the motion.
I think that motion accurately reflects the law.
Yeah.
Okay. The last motion is to permit a brief, limited juror questionnaire. And I've provided a sample of a questionnaire which gives some of the basic facts of the case, and then is followed by some questions. Please tell us everything you have read, seen, heard, or discussed about the murder, rape, and sodomy of these girls. Do you know anyone that might be a witness? As a result of reading or hearing about crimes, do you have any opinions? If you've heard or read about this case, what have you read? What do you know? And if you were told to disregard it, could you absolutely do so? And I'm just paraphrasing those. I think the court's probably read the motion.
Right.
I think that a questionnaire, and I'll be very candid, there's no case law that says that questionnaires are mandatory. But if you look at the case law, repeatedly there have been cases in which, I found numerous cases in which questionnaires were permitted and became subject of appellate issues as to whether or not counsel was able to ask questions that were already asked on the questionnaire, sort of implying that it's allowed and it's permissible, and I would characterize it as clearly within discretion of the court. So I don't have any legal authority mandating it. However, I think that his due process rights to a fair trial and an impartial jury are implicated in that I think the court, it's incumbent upon the court and counsel to do everything that we can to make sure that his rights to an impartial jury and his rights to a fair trial are protected. And one of the ways that we can do that is by streamlining this process. We have a huge number of people to voir dire, and as Your Honor knows, some people who voir dire will rarely raise their hand, but they might very well answer a question on a juror questionnaire. And I think it helps us to streamline the voir dire process, helps us to gain some additional knowledge about these jurors that might slip through the cracks, and it will help speed up the process. I don't think that we'll need to ask as many questions about press coverage as we might otherwise have to do. And I just think with the difficulty of doing a general voir dire with that many people is terribly unwieldy, and that when you get a brief questionnaire like this, it's one page. Most of the questionnaires that have been subject of appellate cases have been 40, 30-page documents, and I'm not asking for anything like that because we're not dealing with the death penalty in this case. But I do think that a one-page brief questionnaire would be helpful.
And tell the court what you have in mind. When do they get the questionnaire? When do we get it back? And how do we distribute it to other counsel for other parties?
Yeah, I think that when they come in, we give them the questionnaire, ask them to fill it out, and then we go ahead and take that questionnaire with us, do the voir dire that we would do, and then consult with the questionnaires when it comes time to actually making our strikes.
Mr. Miller, what's your thoughts?
Judge, I would object to a questionnaire at this point. I don't think that, I think this is going to poison the jury pool the way it's written. I think voir dire should be a fluid conversation between counsel and the court and the individual jurors, and I think this just gives an opportunity for too much to go wrong.
Okay. I'm going to deny the motion for the questionnaire. I may well ask a number of those questions myself of the entire panel because I think that is some information that's valuable that I've never used a questionnaire in all my 40 years, so your motion is denied.
Okay, thank you, Judge. The only other thing that I have is that I would like at some point to bring to the attention of the court an agreed stipulation that has been discussed.
Okay.
It just needs to be.
That's about the qualifications or?
Well, basically, it's a stipulation allowing someone else to testify instead of Dr. Giles to in effect read his medical examiner's autopsy report into the record and answer questions about it. In exchange, the Commonwealth agrees to stipulate to the chain of custody of the DNA samples collected by Dr. Giles so that we don't have to get into
I believe there's an
getting
agreement on
witnesses.
that, is there?
Yes, sir.
If you have an order prepared, I'll sign
I
it.
do have the agreed stipulation. I have signed it, but I need other counsel to
Okay, if you
sign.
circulate
I
that.
believe everybody's on board, Judge.
Okay, sounds good.
And Judge, for the record, I think I've sent everybody Dr. LaBoy's CV. Did everybody get that?
Yes.
Okay. Judge, I do have a couple things I'd like to clarify once we're done.
Okay, I believe that's all the motions, isn't it, or not?
That is all of the motions.
Okay. All right, anything further?
Judge, I mentioned it briefly earlier, but Commonwealth's filed, and I think the court's ordered reciprocal discovery. If there is any report in regard to Ms. Ritchie's investigator speaking to Ms. Abbott, I think I'd be entitled to that.
Okay. I always have to go look at that reciprocal discovery rule each time because I know the duty of the defendant's not nearly as great as that of the Commonwealth. Ms. Ritchie, do you agree that you're required to give that information to?
Your Honor, yes, of course I would agree to give it. I would say that the information that my investigator would testify is in she first found it in the discovery we were provided. So I think all of the things that she would talk about, they already know.
Okay.
My understanding of the rule is that it covers the defense as to things that we intend to introduce. I don't intend to introduce hearsay reports of investigative reports. They wouldn't be admissible any more than the police officer's citation is admissible or report is admissible. It's hearsay. What I will do is I acknowledge the responsibility of defense to provide reciprocal discovery, and we're going to meet today, and I will make sure that one of the number one topics on that is, do we have any materials that need to be looked at in light of the rule and turned over, and we'll make sure that if we have anything, it is. I do have one other issue that I would like to raise with the court.
Sure.
And may we approach?
Sure.
Pre-indictment delay, this case is what is meant by the Supreme Court as an example, a perfect example of why you don't sit on a case for 19 years, how that's prejudicial to the defendant, and how his due process rights are just completely devastated in this case. And I won't go back to it, but we have 3 or 4 pages in here where I have cut and paste all the different areas where he is harmed because of the delay. And again, it was not only is he substantially prejudiced, but it was done in order to elicit a tactical advantage. Because of that, we argue that this case falls under Marion and it should be dismissed.
All right, thank you. Mr. Miller?
Thank you, Your Honor. And with all due respect to Ms. Jones, this is almost the exact same motion that they filed before on a due process violation that the court has heard and denied. So the Commonwealth would rest on its response on those motions that the court has, again, previously heard. Mr. Duncan made several statements fairly recently, and I say recently in this case, which is relative, but to Detective Newby or Lieutenant Newby, that resulted in his indictment for tampering. Those, what I would say, if not confessions, then statements against interest certainly are what led to his indictment and what led to all 3 defendants being indicted on the murder. Evidence has been located. I think since this judge's, your Honor's tenure over the case, there has been new evidence located. It's just the nature of this case is unfortunately things keep popping up because 3 different agencies have handled the case. The Commonwealth has done nothing to hide any of this evidence. We've had an open file discovery policy. It's just the unfortunate nature of this particular case, which I will stipulate is unique. There certainly is not a tactical advantage. In other words, the Commonwealth did not do anything to gain a tactical advantage simply by indicting Mr. Duncan. It was a result of the interview along with the investigation done by Lieutenant Newby. And essentially what this is an argument that a statute of limitations should apply, which the court is well aware there is no statute of limitations on felony.
All right, thank you. Court has visited this issue earlier, and I think the delay is unfortunate for everybody, Commonwealth and the defense. There is no statute of limitations, and so your motion to dismiss the indictment is denied. All right. Which motion do you wish to argue next?
Judge, if we can look at the motion to exclude the reference to the Cat West card.
Okay.
And Judge, we have, in this case, Detective Newby has gone and taken a reference that notes one Cat West card in a property sheet that was retained by the Nashville Metropolitan Police Department back in 1994, and has taken that and conjured up a conspiracy theory out of that reference. That card is no longer in existence. I believe that once Detective Newby took over the case, he attempted to actually secure a copy of Mr. Black's file. It had been destroyed. I understand that it's been destroyed pursuant to their policy. However, there was nothing stopping the Christian County Sheriff's Office in 1995 when they took over the case. There was nothing stopping KSP in 2006 when they took over the case for attempting to locate this. This reference, we're asking for it to be excluded because we simply don't know what this Cat West card was. We don't know if it was a business card. We don't know if it was a promotional sort of card, something like you might get on the Vegas Strip that's promoting the business. We don't know what it was. And the route that they have taken it is this mastermind conspiracy that ties all three defendants together. And that's simply just an overstretch. And I think the rules of evidence in Kentucky state that an original must be provided. We don't have an original. We don't even have a copy of the original. So we have no idea what this is. In essence, what's purported is hearsay. Based on that, I don't think it fits in any of the exceptions for hearsay. We would ask that the reference be stripped, that they not be allowed to reference that.
All right, thank you. Mr. Miller?
Thank you, Your Honor. Judge, the Cat West card that the motion refers to, just to give the court a little background, I don't want to get too far into it because it's part of a 404B thing that I need the court to kind of clarify a little bit later.
Okay.
But what it was, Mr. Black was being investigated by Nashville Metro Police Department. Clarksville Police Department arrested him, and Nashville Metro came down and did a search warrant for his vehicle and his residence. The Cat West card, along with some other things, Tennessee Highway Patrol citations that have been mentioned before, were found in his property. That case in Nashville was disposed of, and pursuant to department policy, as almost every department has, they destroyed the evidence because the case was over. Unfortunately, by the time Lieutenant Newby caught wind of the kind of maybe cross nature of the two cases, the card had already been destroyed, so we don't have a copy of it. What we do have is, as in any search warrant is served, there's a log of property located and seized by the police, and that Cat West card is listed on there. And they're correct, and it just says Cat West card. There is a copy of a Cat West card in the file. Again, this case, and I apologize, the evidence is 2 hours away from my office. That's why I've got an open file discovery. I don't know that we can authenticate that's the card, a copy of that card, because no one is going to remember that's the card. So I don't think that we'll probably attempt to enter that into evidence. What I am going to try to get into evidence is that log sheet through hearsay exceptions, ancient documents, business records, however the court would like me to proceed on that, and I can certainly do both of those things, is a detective from Nashville Metro will testify that that's what was seized in that investigation. Rather than some mass conspiracy theory, Mr. Black told Lieutenant Newby in an interview in Alabama that he had never been to Hopkinsville. And it's more proof that he had been to Hopkinsville than it is proof of some mass conspiracy. The jury can draw whatever conclusions they may. The defense may attack the card and its veracity and whatever they can do. But I think the actual admission of the evidence list seized by Nashville Metro or Clarksville PD, whichever agency seized it, is appropriate and should be allowed in.
I'll take this motion under advisement. Is this something that you wish to file any written response to?
I can certainly do that, Your Honor.
That might be helpful to the
Yeah,
court.
I think just for the record, it may be.
Okay. All right, I'll take this under advisement, give you a few days, if we don't have much time,
Yes.
to file a written response.
And Judge, in the alternative, Detective Newby has repeatedly testified that this card is in relation to belonging to J.J. Burt, and there's absolutely no evidence or proof. So in the alternative, if the court's not willing to exclude the reference to the card, we're going to ask that Detective Newby be admonished to not reference it to anything more than the Cat West card, not anybody in particular's card.
All right. Mr. Miller.
Judge, the copy of the card that we have has J.J. Burt's name on it. I think that's where Lieutenant Newby got that. I think this may be covered under the non-expert speculative conclusion.
That's what I was wondering.
I think that's something that he has testified to, obviously, at grand jury and other investigative parts of the case. But honestly, I don't think he'd be allowed to testify unless we can get that copy of the card in through legitimate means.
Okay.
Whose card it belonged to.
All right, then that much of your motion is granted.
Judge, if we want to take up the motion to preclude any late notice 404B evidence from trial.
Okay. And we're talking about 404B evidence that we hadn't even heard about yet, right?
Correct.
Okay.
That we are now within a week of trial, and we just ask that there be, and I did not file any orders with my motions. I guess in this circuit, we generally don't, and I wanted to make sure that I sent the motions off as soon as I could. I will tender orders where appropriate.
Okay.
But we would just like an order stating that going forward to trial, we're not going to have any surprises as far as 404B is concerned. And that, I think, would be a violation of Mr. Carter's due process rights. This case has been pursued for a while. We've already had 6 different issues brought up in a 404B motion. There is one particular issue that I would like to take up at the bench.
Okay.
Why we filed this, and I would like a ruling specifically on that
Okay.
particular issue.
Number 4, motion to introduce alternative perpetrator evidence. Number 5, motion to exclude reference to the Cat West card. Number 6, motion to preclude late noticed 404B evidence from trial. Next one, motion to produce any Brady, Giglow, Kyles into information regarding Charles, can't read my own handwriting, Daniel, I believe. Motion to redact statements, to delete hearsay and other inadmissible content. Motion to permit the use of limited questionnaires. I believe that's everything. I have it's been filed by counsel for Duncan, notice of joining in and adopting co-defendant Edward Carter's motions. Is there anything that has been filed or is before the court today that I haven't mentioned?
Judge,
Yes.
I have a motion to join the co-defendants, Edward Carter's motions. I've listed them out here.
Oh, okay.
If I may approach
You may.
the clerk. And
Sure,
ask-
that'd be fine.
And I've provided a notice to the co-counsel as
All right.
well as to the.
Very good.
Thank you.
Motion's granted, as is the motion of Duncan. Before we get started with this, and we'll come back to it again, this case is set to begin on September the 6th. And the jury will be reporting that day. Judge Self and Judge Adkins are both impaneling juries that day. And then we have this case. This is the only case that is set for trial that day. Is there anything that you know of right now that is going to result in any kind of late motion for a continuance, or that there be separate trials, anything like that you know of right now?
Judge, I do have two more motions that I'm going to want to file.
Okay,
No motion for a continuance, but I can tell you, if it will help the court and help everybody, to give everybody maybe some advance notice on it. One is a motion to, under the defendant's right to present a defense, Crane v. Kentucky and Gray v. Commonwealth. It's a due process right, and Teresa Abbott is deceased, but her statements pertain to the alternate perpetrator,
Okay.
Stephen Henson, and we're going to ask to permit us to present that part of the defense.
okay,
The other one is we want to make sure that the rule on refreshed recollection is followed. You can refresh recollection, but you cannot refresh memory.
That's right.
And this is
let me think, I remember all that.
this is a,
Past recollection recorded, present
Right.
memory refreshed.
but what, and we'll set out the law on that, but the fact is that this is a case that is 20 years old, and we've already heard witnesses say that they don't remember.
Sure.
And in some cases, the only way to refresh their recollection is with material that is not particularly reliable. And those two motions are the only two motions that I can think of right now that we would have. And I don't see how those would delay anything.
No, I wouldn't
And
think
I'll
so.
raise that issue again towards the
Okay,
end.
all right. Anyone else have any thoughts on any issue that might cause delay or a request for continuance, anything like that? No?
No, Your Honor.
All right. The motions that we have today have by and large been filed by counsel for Carter, Ms. Jones and Mr. Buffkin. So I'll let you all decide in what order we take them up.
Doesn't matter to me.
Okay?
We're going to divide up the duties. on
Sounds
the
fine.
motions, If that's all right with the court.
That's-
Judge, if we could have a moment, I've got a couple I don't have an issue with. If we
Okay,
could
that'd be
confer
great.
for a second.
Let's go off the record.